See if that helps.
Does not.
Welcome back, everybody. Really appreciate the engagement that we've had along the way, particularly in the last few weeks. A lot of really good questions, people reaching out. I had actually a couple meetings from some of you guys that wanted to reach out. Today, we're going to be talking about what generally most people don't want to look forward to or kind of do, but it's a necessity from my chair and certainly from our guest chair. And that's estate planning and the various and sundry things that come with it. So with that, I'm going to introduce my good friend, Lyle McQuinn. Lyle, I really met as he was an advisor to the family, and then we developed a relationship, and I've sent quite a few clients his way because the amount of trust I have in him as an advisor is can't be overstated. And to give you a little background on Lyle, he is specifically in the practice of estate planning. And I know I've met with a lot of participants and a lot of people over the years, and we'll come back to this, some of these a little bit, but and where a lot of people have a general practicing attorney and they go to it because they're a friend, and those people, let me be clear, a lot of those people are extremely talented and they can find general language for wills and some of those things. But in my estimation, I've seen it a couple of times when they did a fine job getting the basics, but it fell short of doing that because it is not a full-time specialty. So Lyle is an attorney, graduated from the University of Kentucky. He also has a master's in taxation law from the University of Florida, which is, most of you all might not understand, but that is actually one of the finest tax law institutions and tax institutions in the country, believe it or not. And somehow he went down there and they gave him a master's, and this is what he makes his living doing full time, is just in the estate space. So Lyle, really appreciate you taking the time to be with us today. A lot of people are excited about this.
Glad to be here.
And so on and so forth. So let's just start real quick, Lyle. We'll go back and forth a little bit. You do your thing. You know how to do it. But let's just start with the basics. What is estate planning, and why do we think it's critically important?
I always get the question, what do I need to do, or why do I do it at all? Here's one thing everybody needs to remember. Anything you don't decide for yourself and your family will get decided for you. If you don't decide who can make financial and healthcare decisions and you become incapacitated, the court gets involved. If you don't decide legally and put in place who receives your assets and how they receive them, the court and the legislature get involved. And the problem there is people get caught off guard. Spouses don't automatically inherit everything. You as a spouse or as an adult child don't get to go in and just get to making decisions for financial and healthcare matters. And so when I tell people the reason that you need to put something in place is this: everyone has a choice, and that is the choice to put their own plan in place that carries out their wishes, puts people in place and where the assets go, or they have the choice that the government gives them when they decide everything for them.
Yeah, and to be clear, we have people on this call, Lyle, from multiple states. There's a huge concentration on this group, and not only the ones that are on here, but the ones that will be watching later, from Michigan, Ohio, Indiana, Tennessee, Massachusetts. I know there's some on the call. So to be clear, a lot of these things that we're talking about, there's a lot of generalities that are common amongst the states, if I'm right, but there's a whole lot that states have some state specific stuff in there too, which is even more important, I think, to have a specific, estate attorney when you're looking for that. And we'll talk about your kind of thoughts on finding those people a little bit later. Obviously there's several components and documents that are needed for an estate plan. And after sitting in rooms with you and clients over the years, you always do a great job of breaking it down of what you call above the ground planning while we're still alive and on the rock, and below the ground planning after we pass. So let's talk about the former first, in terms of above the ground planning. So how can I protect myself and my loved ones while I'm still alive, and what documents should people aim to have at a minimum on that?
At a minimum, if you are above the ground, as they say, if you become incapacitated and all of a sudden can't start making decisions for yourself, you need to have a power of attorney first off. A power of attorney is a document that typically says who can make financial decisions for you when you can't. But saying you have a power of attorney is kind of like saying you have a car. There's a lot of different types. I always tell people, think about what you want the power of attorney to do. Typically, it's to be able to make financial transactions for somebody, sign a tax return if they're incapacitated, go to the bank for them and do some banking. But it also oftentimes needs to allow gifting. There are ways in a lot of states that if a person went into a nursing home, if they had the right type of power of attorney, then the family can use that power of attorney to help save the house, save the assets, and things like that. So from a financial standpoint, I'm always going to say you have to have a power of attorney, period. If you don't, then you go through the court system to allow somebody to petition the court, typically what's called guardianship and conservatorship, to be able to make the decisions. Here in Kentucky, like most states, it's a jury trial. You have to convince the judge that the person's incapacitated. They typically will hire a doctor, a psychiatrist, and a social worker, and you're going to go through a month-long process, oftentimes ending in a jury trial, to say, yes, Mr. John Doe is incapacitated. After that, you have to go say, well, judge, now that you found him incapacitated, or the jury has, I should be the person who's put in charge. And you go through that. And it's the same thing for healthcare. I tell everyone that I typically look at the law as broken into two categories: financial decisions, healthcare decisions. Sometimes you want to name the same person. Sometimes you don't. But I always want you to think about, if you're laying there in the hospital and the doctor walks in and the doctor says, well, it's 50-50 on which surgery we do. If you can tell the doctor, fine. But if you can't, then either someone's going to go to court to try and get permission to tell the doctors what to do, or you have the right power of attorney for healthcare, oftentimes called a healthcare surrogate, in place that simply says, dear world, if I can't give medical consent because I'm unconscious, or they say that I'm out of it a little bit and don't understand what I'm talking about or be able to give consent, that document says in those cases, doctors, nurses, here's who you may listen to. And we usually couple that up with what's called a HIPAA authorization that allows access to medical records. Because Hunter, for example, if I name you as my healthcare decision maker, I want you to have access to all my medical records. And then finally, I always tell everybody, one of the most important documents to help your family is a living will. A living will is a document that says if certain criteria are met, then I'm telling the doctors, I'm telling the nurses, and most importantly, I'm telling my family, it's time to let me go. Usually those parameters are that 2 or more doctors agree that you're permanently unconscious, clinically brain dead, no chance of recovery, that they can keep the body going with respirators, ventilators, but you will, under all degrees of medical probability, never come back to. I will tell you, in my experience, I've been involved in many lawsuits where a person didn't have a living will, and one child comes in and says, Dad always told me he would fight forever, no matter what, never pull the plug. And the other child comes in and says, Dad told me he would never want to be in this state. He wants to go on and see the people who've predeceased. He'll wait for us on the other side. Well, you get that emotion involved in a very traumatic time, it can tear families apart. I have never, and right at 2 decades of doing this, had a family fight over whether to pull the plug or do those extra measures when the person had a living will. I tell everybody, have a living will so your family knows it's okay, if that's your wish, to go ahead and stop and let you pass away naturally. Otherwise, I tell people I've had kids that don't talk to each other anymore, both of them believing they absolutely did the right thing, both of them truly trying to do the right thing, and that family gets torn apart. So please, of all things, have in place those types of documents so we all know, and it doesn't come back to he said, she said, and families no longer talking.
And not only that, I mean, just from hearing, I know you've had a lot of experience on all sides of all of those issues, but in terms of what people I think miss the boat on is that those things actually protect assets that you intend to be passed on versus to be spent for attorneys, or as anytime you put the word emergency, and if you want to petition the court for an order of emergency guardianship, that is not a cheap process, because the word emergency in itself makes the cost go up for everybody involved, I believe. Am I wrong?
You're absolutely correct. And here's what I tell everybody. I want you to pretend your loved one is up at the hospital, and perhaps it's down to days or hours. Do you really want to spend a lot of money, and above that, spend a lot of time with me in the court system? Or do you want to be there with your loved one?
Yeah.
I want you to be there with your loved one, and that just takes the small amount of planning to get that in place so everyone's there and can be there.
Yeah. Okay. So power of attorney, healthcare surrogate, and living will, right? Those are
absolutely
main things. Yeah. Good. Okay. So let's move on. Let's talk about the post-mortem part. That's what everybody, I think, I kind of mentioned those before, but what is the actual legal process that takes place after one passes? Let's start there.
So most people have heard of it. It's called probate. And probate is the court system that gets involved, that takes the assets that an individual owned, that didn't have any type of designations or anything on those. And the court gets involved and says, okay, inventory all those assets for me. Claim their values. Tell me where they're at and everything about them. Go get them appraised. And then after a set amount of time, called the creditor claims period, eventually the court says, now here's where those assets go. If a person has not themselves determined that by wills or trusts or those things, it is the court and the legislature that determines that. And the reality is, in an awful lot of states, people mistakenly believe, well, if I'm the surviving spouse, it automatically goes to me. Do not make that assumption. It oftentimes is incorrect. For example, here in Kentucky, there's a few exceptions, but Kentucky says if you pass away and your assets go into the probate process and you don't have a will or anything, you're going through what's called intestacy. And the legislature says, well, there's a few exemptions for the spouse. Otherwise, the assets go to the kids. And if there's no kids, the parents. And if there's no parents, the siblings. And I see people get caught by that all the time. So when a person passes, when you fall into the court system, that's what you hear people talking about probate. And literally one of the biggest misconceptions I hear is people say, well, I don't go to probate because I have a will. It is literally the exact opposite. Because all you have is a will, the will itself has to go into court, has to be probated, has to be accepted by the judge, and the court is going to be in charge of that entire process.
Yeah. And does the probate typically have costs that are associated with it?
It absolutely does. When you go into court, almost always you're going to have an attorney, because you have to do tax filings, you have to do the right appraisals, decisions have to be made. And those really should be made by an attorney. I had an individual in my office a few minutes ago, and luckily we're 4 days away from a deadline. He didn't know he was 4 days away from a deadline. It's an $800,000 change.
Oh boy.
And so I told him, it's Friday, you stop, you do not go back into work, you go to your CPA, this has to be done today. We've got 96 hours. Because that probate process determines what happens. He was just kind of going along with it, waiting on things. But probate, you have to pay the court to be there. You have to pay the filing fees. You've got to pay the county clerk typically to record the will. You're going to pay the attorneys. And a lot of times attorneys charge a percent of the state, 1%, 2%, 4%, whatever it is. Also, just so that heirs can eventually get what's left over. And make no mistake, probate puts the court system in charge. Yes, you may be appointed the executor, but you are appointed the executor by the court to carry out the court mandates. You go and ask the court's permission to sell property often. You go ask the court's permission to where the assets are going to go. And every time you're in court, it's costing time and money. I always joke with people and say, if you're in probate, what that really is the attorney retirement system. Because we get to take part of that inheritance, we get paid for being there.
Sure.
And I always tell everybody, when a person passes away, if they go into probate, I do know one thing for certain. That is, they will not receive 100% of the inheritance, because you are going to pay the court system to be there. You are going to pay filing fees. You are going to pay recording fees. And you are going to spend quite a bit of time. You know, here in Kentucky, for example, which follows what most states do, it's a half a year. So you think about that. Your heir passes away, the assets go into probate, and the judge is overseeing those for a minimum of a half a year. And those assets remain frozen so that creditors can come in, so the tax man gets to come in. So all those sources come in. And then when probate is done, whatever's left over goes to the heirs. It's a very archaic, very expensive system.
Yeah. And most of the time, I know in Kentucky that 6 months might be average, but my uncles took 9, and that was on the short end, I felt.
Yeah, absolutely.
And he didn't have much. He didn't have much.
Well, I had a woman come in Monday, and I was like, look, it will likely be this time next year before we're done. And it's just the way it is, because all she had was a will. Yep. And, you know, with the pandemic or the court schedule, we simply can't get into court for a month and a half.
Yeah, sure. So let's go into documents and instruments in terms of the minimum that ideally, and then, obviously, I know your opinions on trust. We're going to talk about that in more detail in just a second. But what kind of instruments or documents in place for the below the ground planning do you have to kind of make it easier?
So typically, I want to tell an individual to have a last will and testament and a revocable trust. Those two go together, and kind of think at the very top, the will is the waterfall. It says when I pass, my will says everything goes to my trust. Whatever it is, if I forgot about things, it's what's called a pour over will. Pour my assets to the trust. And oftentimes you will have already used what's called a revocable trust, some call it a living trust. Over the years, I've started calling it a revocable living trust, so everybody knows we're talking about the same thing.
Yeah.
But by using that trust planning, it allows you to short circuit the probate process. Think of it like this. A last will standing alone is extremely important versus having nothing. Again, always remember, if you don't put anything in place, it is the legislature and the court system that defaults you into a plan, and that can have very serious consequences from a tax standpoint, who inherits, etc. If you have the will, that alone will help, but it takes you through that probate process we just talked about, which means, yes, my will may say when I pass, everything goes to my spouse, or if my spouse isn't there, to my kids. But if the will alone is doing all that, the court system stays involved for that entire process. Okay. If instead you implement a revocable trust, again, I think everybody should have one. A revocable trust is a way to say, you know what, court? I'm going to avoid the probate process. I'm going to avoid reporting to you because my revocable trust will take over. And it says when I pass, the assets will be administered by my trustee, oftentimes the surviving spouse, or if there is no surviving spouse, the kids. And my revocable trust says when I'm gone, little Tommy and little Susie get 50-50 and done. If I use that trust to do that, then they can get the assets instantaneous at death, not going through the probate process, not going through the court process. If I say the same thing, but only do it in a last will and testament, it's going to take little Tommy and little Susie a year oftentimes to get the assets, and they won't get everything because they had to pay the court and all that to be there.
Yeah. Yeah. And you stole my thunder there, but most of the people on the call here have heard me say that there's a huge misconception out there about who trusts are for. Most people think it's for ultra wealthy or spoiled rich kids, as I like to say. And I think that the coined phrase trust fund baby really kind of ruined that, unfortunately, but it's really not. I mean, at its core, I've heard you say it, all a trust does, particularly in revocable in this case, is it transfers one asset or multiple assets from one person to the next in the quickest, most efficient way possible. And to be clear, trusts are the only instruments that can bypass the probate court, correct?
That's right. I mean, you use a trust to take assets that would normally go through probate and avoid it. And I simply tell everyone, a trust allows you to say, I hereby give X, Y, and Z to Tom and Sue, and they get it. If your last will and testament is what is saying that, it is the court that does it.
Yeah.
And anytime I say court, you just think attorneys /time/money.
Yeah. Yeah. And I would guess, I mean, a revocable or a living trust is the vast majority that fits. There's a lot of different trusts. We're going to talk about a few of those in a second, but the vast majority of basic trusts are revocable or living trusts. So explain a little bit what that exactly means.
Okay. So a revocable trust is something you put in place that basically will say, if I'm incapacitated, you all may put my assets in here and manage them for me because I'm incapacitated. So I stay out of guardianship and conservatorship with the court. And the revocable trust says, now when I pass, here's where my assets go. And it's called a revocable living trust because it's there while you're alive and it can be changed and amended. You've got to be careful sometimes in putting a plan in place, because I'll have people say, well, what if life changes? What if I don't want to do this? A revocable trust can be amended and changed by you as many times as you want when you set it up. I have an individual coming into my office in 2 days. One of his children literally won the lottery. Not a huge sum, but he's going to be doing okay. And so this single parent now said, well, it's not that I don't love my kids the same, but one child simply isn't going to need as much. And so now I want 75% going to one child and 25% to the child that did win the lottery. And so I always tell everybody a revocable trust can morph as you morph through life. You can change it. You can maneuver it. And it simply says, well, I'll steal my old law school professor a few decades ago always said, with the last will and testament, you get whatever's left over after probate. And it'll take you a year to get it. But with a revocable trust, you can pass away at 8 o'clock in the morning and your heirs can have everything at 8:01. Now, he always said, though, if your heirs come in that first 1 minute to get the assets, you may have left it to the wrong heirs.
Sure.
But the whole point was a revocable trust says, carry out my wishes outside of the court. We don't need the court involved.
And while you're alive, you can make changes to it fairly.
Absolutely.
So in other words, if you were to put your house in a revocable trust, it doesn't preclude you from selling your
Correct.
house. It doesn't,
Correct.
it's not the irrevocable, I think is what a lot of people, and irrevocable simply means that it goes in there and it cannot change. The language
That
of
is
it,
correct.
is perpetual until the trust is, evacuated, I believe. So, that's, I think that's a real big important piece for people to understand. And let's go back, because this pairs with it, I think. Probate is done where the asset of the person who died located, correct? So in other words, if
Yes.
I'm in Kentucky, but I own a hunting cabin in Tennessee, that means when I die, not only do I have to do probate in Kentucky, but I also have to do it in Tennessee, correct?
That is absolutely correct. I always tell everybody, think of a state's borders. And when you look at that state can only control the real estate inside it. Kentucky can't tell Texas what to do with it. We can't tell Tennessee what to do with it. So one of the things I always tell people, if you own real estate in multiple states, it is insanity to not have a revocable trust.
Yeah.
Because you are setting your heirs up to go get that out-of-state real estate. They're going to spend a year plus in doing it and thousands of dollars unnecessarily.
So the trust then can be established in the state where you're at, but it is honored. If that asset is owned in a trust, it still avoids the probate in other states.
That is correct. It's like your driver's license.
Okay.
If you get in your car and drive from here to 4 states away, every time you get pulled over, your driver's license still works.
Yeah. And then another nice thing about it, I'm not going to get into the weeds of this, but the revocable trust, because the assets come immediately, allows the trustee to be very tactical. So there might be assets owned by the trust, but they don't have to stay in there.
Correct.
That you might want them to for liability purposes, but you can kick something out of a revocable trust fairly easy, even post-mortem. Is that correct?
That is correct. I'll give a quick example. My mom has a revocable trust, and at her passing, she's going to have a stock account, a car in her house, and maybe a checking account. All those will go into the trust. We will be able to administer those instantaneously. The neighbor, in our case, said he wants to buy the house at her passing. So I suspect that should my mom pass, within 7 days, I will have everything through the trust distributed, 1/2 to me, 1/2 to my brother. It won't cost anything, and we will be done with the entire process that quickly.
Wow.
If my mom ever decided she didn't want something in the trust, she could change it and amend it. If I win the lottery, my mom could go and say, I'm changing this trust with one line to say it's no longer going 50-50, it's going 80-20. My mom could say, I want to change it to give some to the grandkids. But a revocable trust is really just your alter ego. And you can change and amend as often as you want. And I do sometimes get the questions, well, how often should I change it? Well, that depends. You change it based on life changing. My mother's revocable trust has been in place now for about 10 years, and we have not changed it once. Why? Because it says at her passing, it goes 50-50 to my brother and me. Now, my mom about a year ago said, I have considered giving some to the grandkids. My mom hasn't done that yet, but if she decides to do that, it'll take us about 2 minutes to make that change because her wishes have changed. And so I tell everybody, you leave it in place until your wishes or life changes, and then you make a quick amendment.
Great. Yeah, that's perfect. Eric, I saw one of your questions. I'll answer it real quick. Is the revocable trust the same as a living trust? Yes, is the answer. Yes. Those are the same type languages, and you'll hear one or the other from place to place, state to state. So let's talk. Just move on to the kind of. We're just going to touch on a couple of these, and some of them we already did, but kind of show examples of how beneficial trust can be, because everybody's situation is different. Sometimes people's situations become different because of life circumstances, for sure. And I know you deal with that all the time, but obviously we talked about an irrevocable trust. Those are where assets goes into the trust, and it just means the terms of that cannot be changed. Pretty much, it's very difficult to change that if at all, correct?
You can change them a little bit, but predominantly you are correct that those types of trusts stay there, and when you set them in stone, you've set them in a means that they're going to be in place forever.
Okay. Another type of trust that I know we shared a client in on, and it's always beneficial to understand a little bit on it, but why don't you touch quickly on like a Medicaid protection trust? So I know you talked a little bit about the Medicaid,
Sure.
and look back and recapture earlier, but talk about how something like that can be beneficial for somebody.
So from just a 10,000-foot view, Medicaid says that if somebody goes into a nursing home, they must be broke. Simply put, with just a very few exceptions, they have to spend all their assets down to $2,000. Well, let's take an example that we have a single parent and dad passed away and mom is still with us, and we know that mom is in her forever home. Mom is going to live there. She's lived there her entire life. When mom passes away, this home on the family farm goes to the kids. Oftentimes you will say, well, since we know that mom is wanting to pass this on to the kids, since we know that mom may go into a nursing home someday, a lot of people will implement a Medicaid asset protection trust that mom will take the house and deed it over to that trust. Now, when mom deeds the property over, she says, I, mom, hereby deed the property to that Medicaid asset protection trust. That starts that 5-year look back. Some people have heard that Medicaid says, well, when you go into a nursing home, let's make sure you didn't just give all your assets away the day before so that Medicaid pays. Medicaid looks back 5 years. Well, if mom deeded her house to the trust more than 5 years ago, that house, that farm is now fully protected. If mom ever goes into a nursing home, she won't lose the home. And you can do that with other assets too. Now, a lot of times I'll have people say, well, this is my house. I don't, what if they kick me out? Well, what you do is you deed the house to that trust, but mom in that trust retains what's called a life estate. And that is, I hereby deed the house to the trust, but for my life, this deed gives me the ability to live here, paint the walls. We can do it to where they can sell the property still in those things. But doing that is a way to protect the assets from Medicaid. And one thing I do want to touch on there, it's also about beneficiary designations. I always, when I talk about Medicaid, I tell everybody I see a tremendous amount of problems that people believe transfer on death, payable on death, beneficiary designations, or survivorship are great. They can be amazing. They can be terrible. I will give you an example. Mom and dad come into my office in their 60s and they're fine. Dad's IRA says if I pass, it goes to mom. I have no problem with that. 10 years later, dad comes in and he says, well, I'm all alone. Mom's in the nursing home, or mom has Alzheimer's. Well, what happens if dad dies and that beneficiary designation says it goes to mom? That's a problem. What if they have real estate that's survivorship? All the time I have people tell me, well, I've got this real estate in survivorship. I don't need to do anything. Well, in my example, you have mom and dad. They have the home in their joint name. Mom goes in the nursing home. Dad passes away first.
Oof.
Now, the person in the nursing home survived. The house goes to them. The nursing home says, thank you. The IRA goes to them. The nursing home says, thank you. The life insurance beneficiary designation says it goes to mom. The nursing home says, thank you. I tell people, when you're thinking of Medicaid and trust planning, be careful with beneficiary designations. You do not want a beneficiary designation pointing to somebody in a nursing home. Hunter, you and I have worked together, and you're very good at this, that the moment somebody experiences Alzheimer's or gets that diagnosis or has the stroke, you immediately start to say, let's look at our beneficiary designations. 2 weeks ago, they were perfect. Husband to wife, wife to husband. Now one of them went in the nursing home. You don't ever want to point assets to somebody in a nursing home.
Yeah, that's fantastic for sure. Let's talk about one other one that you and I have dealt with, and in fact, you and I are meeting after this. I'm gonna have to talk to you about this very thing. Another type of trust that might impact some of the people, or eventually could, are special needs trusts. I'll use my nephew as an example. My nephew was born with cystic fibrosis. Cystic fibrosis was one of those things that 25 years ago, the life expectancy wasn't even 25 years. And now that's up in their 40s and 50s and 60s. But my nephew is deemed by the government, in order to get medical benefits over and above, he is deemed as has to qualify for it on Medicaid. So he cannot have over a certain amount of money in his checking account. And this is pretty much, even though he's partially on my brother's policy because he's not out of college yet, but eventually anything he has over and above that will be subject back to that Medicaid recapture for the insurance or disability portion of that. I know there's two types of trust. Let's just talk about the third party trust and how that can be helpful for someone who might have a kid with special needs.
Anytime you have someone with a special need that receives governmental assistance, the vast majority of the programs are means-based.
Means-based, yes.
Which says, if I'm the government, I am saying, dear person who has the disability, you must have assets less than, and the typical is $2,000, or we will not assist. So the problem is, if a parent, for example, has a child with special needs, cystic fibrosis, autism, Down syndrome, and some others that come into play oftentimes, if the parent leaves that child outright their assets, then that inheritance is a countable resource. And if it puts them above $2,000, their governmental benefits will shut off immediately.
Or shrink.
Okay. And the way that you combat that is what's called a third party special needs trust. The government addressed the concern saying, we have an issue. We are saying that if a child has more than $2,000 in assets, we're either going to stop their benefits or greatly reduce them. So if what we're doing, we are requiring parents to disinherit their kids. The way they combated that and said, well, we don't want to do that. So they created what's called a third party special needs trust. It is a type of trust that can receive an inheritance or receive anything from anybody in the world other than the person who it benefits. So in your case, your nephew.
Yes.
Everybody in the world could put money into that third party special needs trust, only your nephew can't. And the government says if you set that trust up and you put the inheritance in there or gifts in there or whatever it is, the government says, you know what, we will not count that against this child or this beneficiary. So when the government means tests and says, okay, do you have more than $2,000? They do not count the assets of the trust.
Yep.
Hugely important.
Hugely.
And that trust typically says, okay, the assets went in here. They can only be used for this beneficiary while he or she is alive. And you put somebody to watch over it, a friend, a family member, a sibling, the child's parent, depending on who it is. I have a lot of grandparents who will set up those types of trusts for a grandchild and say, well, if I'm gone, I'm the grandparent. This goes into the special needs trust for my grandchild, and my son or daughter can watch over it. But it's a way to say, I'm going to leave you an inheritance, but I'm going to do it in a way that the government benefits do not cut off, And this third party trust can supplement what the government is helping with.
Yeah, yeah, and in addition to what people need to understand on that. So an example, the means test covers all kinds of different things. It's not just money in the bank account. So for example, if my brother wanted to pay rent for my nephew when he starts to get a house, over a certain amount of money is deemed against the means test, meaning that even though he's just giving in the money for rent, but if he puts it and the special needs trust can pay it and not. And they have state accounts that everybody can get, I think up to 15,000 a year. I think they're called stable accounts as well, that can go in there. But it's just, I don't want to get too deep in the weeds on that, but I know there's people on the call that have kids or grandkids that are going to have a need or could have a need in the future, that need to understand that there is like, you're not just you don't have to be just stuck in that kind of Medicaid means test hell in order for a kid or whoever to keep a benefit long term for those kind of things. I just wanted to bring that up to kind of really just spur the moment. I mean, these are all questions that individuals, the right plan, the right documents, that's a conversation to go along with kind of all your advisors, whether it be financial, estate planning, and those kind of things. And lastly, the one thing I want everybody to understand on this, and I got just one or two more questions. We're going to take some questions that I see have been written. But one thing I want everybody on the call to remember and understand, that an estate planning is part of a financial plan. Financial plans and estate plans are malleable. It is not a one-time and done thing, ever. I've tried to implore this to you on the first time. It is a tool that you use going forward for planning purposes. And when events in your life change, the plan has to change with it. So just because you get these documents in place doesn't mean they don't need to be looked at from time to time, or don't need to be changed occasionally, or maybe it's just the parties in there. We don't live forever. People that we wanted to be in that position, they might have a life event and it can't be. So there's all those reasons of why to do it. So that goes to, last couple of questions here. How often should someone be reviewing these documents, do you think?
First off, anytime there's a life event.
Yep.
Okay. A child develops a disease or ailment. Someone passes. Your thoughts pass. Like for example, I have a person who I'm meeting with this Sunday who's flying in. Their last child is attaining age 40. And they said, I always said that we'd helped our kids enough. Now I want to change that. Instead of it going equal among my 3 kids, I do want the grandkids to get 10%. So I would say at a minimum, every other year or maybe every 3rd year, if life is staying static. But again, the moment life changes, someone passes away, a disease or ailment, your spouse develops a disease or ailment. We get older in life, and unfortunately, I've done this long enough that every month or so, somebody will come in and say, I got a diagnosis of early stage dementia. We need to spring into action, because oftentimes you will have your spouse listed as your power of attorney. Oftentimes you will have your beneficiary designations, just to show how close this goes with financial planning. The moment someone walks in and says a life event occurred, they need, and I always direct, we need to get the financial advisor on the phone. Because if mom was diagnosed with Alzheimer's, how are those beneficiary designations from dad reading? I don't want them going to mom anymore.
Yeah.
Or may not. So every 3 years, I say at maximum, but always know that if life changes, and like, Hunter, you and I have done this, and you've done very good at when you do things for clients, saying, okay, here's kind of your cheat sheet.
Yeah.
And your cheat sheet, you pull out and say, who did I name as my healthcare surrogate? Oh, I named my oldest child. Well, my youngest child ended up going to med school, and, maybe you want to change that.
Yeah.
Or I had here recently, first time I've ever had a client have somebody move to Antarctica, but they're a scientist. They're going to go down and for 18 months study glacier things in Antarctica. And this person's up in age. And so, as we get closer to the end, life events can happen. So we are changing for this 18 months to be from the oldest son making medical decisions to the youngest son who lives in town.
Yeah.
Now, when they come back from Antarctica, maybe we change it back, but you always just want to kick the tires a little bit and say, this is what I'm doing.
Yep. Yeah. Perfect. For advisors, I tell clients all the time that, when we do a financial plan, the purpose of us getting together and having regular reviews isn't just telling you what your account did. People can look that up online. It's not comparing what it did to the benchmark. For us, it's comparing what your accounts have done compared to the financial plan of what we projected would occur. And really the biggest reason is not even that. The biggest reason that we get together with clients on a regular basis is just to make sure not much has changed in their life from what we originally thought. And that's really what it comes down to.
And here's one of the biggest changes I see. A child gets divorced.
Yeah.
If a child gets divorced, I really don't care that their last name may or may not have changed. I don't really care. We update the documents, but legally we would get there anyway. But a lot of people, as you were mentioning earlier, Hunter, say, well, I'm not, Daddy Warbucks or Miss Warbucks. Do I need a trust? My mother is using trust planning so that when I receive my inheritance, it will stay in trust. I'll control it and use it. But if I get divorced,
it's not
then
marriage.
Everything stays with me.
Yeah.
A lot of people think, all this trust is a vehicle for the ultra wealthy. Well, I say, look, if you got $100 million and lose 20 million, I don't care. You still got 80 million.
Yeah.
But if you've got 300,000 and it goes to 2 kids and they get 150 each, and then one of them gets divorced, I hear people say, well, oftentimes my inheritance isn't subject to divorce. Yeah, for about 45 seconds. And then you commingle it, you put it in a joint account, and the judge says, now that's a marital asset, and a divorce walks away, and your child just lost and your grandkids lost.
Yeah, I always joke around the one you did for me. I told Amanda, I said, after I kick the bucket or get hit by a beer truck, you can finally go find that man of your dreams. But he's not going to have the comfort in knowing that anything that we've accumulated and done in our lifetime is going to him, because that's the one thing that's not happening with me. You can go get Josh Mendez or Justin Timberlake or all these guys she drills over all the time. Okay, lastly, really quick, and then we're going to take I'm going to read some of these questions and go into it. What's the best way? Obviously you're in networks with other estate attorneys, but what do you recommend that someone looks for when they're going to go try to find somebody?
I want you to find an estate planning and an elder care attorney. Okay. You do not, this is an old saying, everybody's heard, you do not go to the pediatrician to do your heart surgery. Well, you need to find someone who specializes in this area. So you need to look at their bio. I would ask them, how many trusts do you set up a year? Because frankly, if you're not setting up a lot of trusts, like at least the revocable trusts, then honestly, you're probably not an estate planning attorney. The problem I run into, I see a lot of people who on their website says, I do corporate securities law, I do divorce, I do child custody, criminal, and estate planning. You don't know what you don't know. I had a good friend of mine who was one of my best friends through college. He's going through a divorce. He said, Lyle, I will pay you any amount of money to do the divorce. I just want to trust somebody that's doing it for me. And I said, I'm going to do you the best legal advice I can. I'm going to get you to a divorce attorney because I don't know divorce law. I know a little bit, but I know enough to be dangerous. So when you're looking at it, I would interview 1 or 2. And the questions I would ask are, can you help me avoid probate? How often are you in probate yourself? Because if you tell me you're in probate all the time, I want to know why. Remember, probate is just the process of taking what you left behind into the court, then to your heirs. I don't want you in probate a lot. And I want you to say, okay, tell me how protected my assets are and ask this question. when I pass, what happens? And they should be able to give, well, with this planning, a very direct answer of here's what will happen, here's the phone calls that'll be made. And if they can't, then perhaps you're with someone who's not quite as skilled in that area as you want to be. Because here's the thing about an estate plan. Every one of them will get used.
Yeah, that's right.
Period.
Father Time bats 1,000.
Absolutely. You know, nobody gets out of here alive. So I would, you know, my mom asked the question to me many, many years ago that was very pointed when my dad passed. What do I do now? That's the question. Well, if you have documents in place, it's you simply go to the bank, take this name off of it, open this account, move it over and go. If you're going through the probate process, I'm not sure what to tell you. The court's going to tell us what he or she wants and go from there.
Go from there. Okay, let's take a couple of these questions. Some of them will be super easy. Kathy asked pretty early on, do you need a living will in place if you have a healthcare surrogate power of attorney in place?
Absolutely. Every state that I'm aware of, and you know, I stay pretty up to date on all 50 states as far as just general requirements. A living will really came into play years and years ago with the Terry Schiavo case. The Terry Schiavo case was a case out of Florida that a woman, her husband wanted to pull the plug because she had suffered very severe brain injuries, could not sustain life on her own, family didn't want to. Your living will is your declaration of when to stop healthcare, the respirator, ventilator, life prolonging treatment. Your healthcare surrogate is kind of putting somebody in place to make decisions up until that point. A healthcare surrogate is, do I put a Band-Aid on it or do we do brain surgery? Everything in between. Your living will is, here's my direction on when to pull the plug. I'm not putting that decision on anyone.
Right. Okay. My friend Eric, I actually met with yesterday, asked, where should these documents be kept so they can effectively be employed, and do these documents need to be notarized or some other authentication applied?
They typically are witnessed and notarized. Each state varies, but almost every state requires witnessing and notarization of your living will and will. Now, here's a little secret that you all probably have never heard, but I'm going to share it with you. Accidents only occur at 5:01 on Friday, proven fact. And at 5:01, the bank has just closed. If you keep your documents in the bank, then you're either going to have to commit a felony to break into the bank to get them or wait till Monday. So I tell everybody, one, keep an electronic copy. That's easy. But keep your binder or whatever envelopes they come in your house and let your family know where they're at. For example, if you and your spouse are driving the car and the car wreck occurs and you've named your oldest child or youngest child or whoever to be your healthcare decision maker, they need to know where those documents are.
Yeah.
And they need to be accessible. I can handle kicking in a door because I lost my key to rush to the hospital. I can't handle waiting 48 hours on a bank to open to go in there and get the documents. Keep them at your home and have them accessible.
Yeah, yeah. Eric, I would add to that typically, you know, and I know you're a do-it-yourselfer guy, so you might need to keep copies with your kids electronically or something like that. Most good financial advisors that I know, they want copies of all of that stuff. You know, I'm not an attorney, Lyle does it, but we have other attorneys that, you know, that people get with and have relationships with, and that I try to get those electronically. And I just told them, I said, make sure your kids know that we have copies of this stuff. So that way, if something does happen on 5:30, you know, I can go to my office and print out a copy in the middle of the weekend. That's not a problem for that reason. Eric, just real quick, he didn't say, he didn't have a question, but he said, my parents' living trust saved me and my siblings so much hassle. Do it. Another question, if you have right of survivorship on an asset, do you still put it in trust?
You possibly do. Again, think of husband and wife. That's typically the survivorship scenario you see. It's perfect until it's terrible. Well, what do you mean? It became terrible the moment Mom went into the nursing home, and now dad passed away and it went to the survivor. So survivorship and those things are good, but they are not end all be all. Do not set it and forget it, as they say.
Yeah.
And that's one of the things that, Hunter, I've seen you do many times over the year correctly, that when a life event occurs, look and change it.
Change it. Yeah. Yeah. Let's see. John said, based on a personal experience, I was named as a successor trustee within a will with a family trust section. Once both spouses have passed, will court documentation be produced, which can be provided to banking institutions, i.e. the lawyer who filed the will said the will becomes a trust once both spouses pass. However, the bank is looking for a specific trust and or court documentation on that. That's a great question, by the way.
So I have come to the conclusion over the years, and I hope I don't offend anybody, but banks are their own little countries.
They are.
And they make up their own rules.
Totally. They did with my uncle. Totally.
You never know what a bank needs, but if properly done, then what you typically can do is what's called a trust registration that says, here's the name, here's the date, here's who's in charge, and here's their powers, and give that to the bank and go. But I have quit even guessing what banks want. I always tell everybody, if a bank is involved, you ask them what they want. I had one not too recently, that said they literally wanted a trustee registration on blue paper. I have no idea where blue paper came from. I asked them that. I thought they were joking. At first, they were not. Well, I had to go to Walmart and buy blue construction paper and put it in my copy machine and send it, and they accepted it.
Yeah.
And I was, just so you know, construction paper is about $3.85 for a roll, and I have a whole thing of blue paper because I never knew I'd need it.
Yeah, I can tell you what you're saying about banks for sure. Number one, because I worked for one for a while early in my career. But number two, my uncle and I, we owned a part of a farm together. We had a farm account. We had to have all the members of the LLC sign that we gave him authorization to manage, even though he was a member, to manage the account. When he passed away, because we only had one signature on that, the goalpost moved, I'm not kidding you, 5 different times on what they wanted. 5 different times. And finally, I called somebody who knew him. I said, listen, we have produced everything. And it took us 12 months. And they took $20 a month for all 12 months in that business account going out of that account, just so everybody knows that.
Well, I don't want to one-up you, but I had a bank request that the individual come in before they would do anything after I produced the death certificate, and it took them a month before they would finally agree there was not going to be too much of a way I could produce him. So that's my top story currently.
Eric asking again, to put a house in a revocable trust, do you need to retitle it to the name of the trust on the deed?
You do, and you simply do the deed. Very simple to do.
Yeah, you can do a quick claim deed on that, Eric.
That is correct.
Very quickly to do on that. How often should the revocable trust be updated when one has children?
It depends on how old the kids are, a lot of times, but really it depends on what your trust is doing. Most of the time people have a trust that say, if I'm gone, it holds for my kids. And they will put in there who's in charge of the trust till the kids hit a certain age. I typically default to 30. I don't like to let the kids be in charge of the trust. They can benefit day one, but I don't like them to be in charge until they're 30. The reason being, that trust for the 25-year-old can still kick out money for school and college and help buy a first house. But I like people to have a little bit of maturity. And I always tell everybody, you will never harm a kid by making them wait a little bit longer to be in control. They still benefit, just not in control. But if it's a young beneficiary that you have, update it when the guardian might change. People move. I had recently, my best friend had to change his. He had named his legal guardian as his best friend that lived next door to him. They were going to take over for the kids and all that. Well, he got stationed down in Texas now, and his kid's a sophomore. God forbid if something happens, we don't want the kid going to Texas. She's a sophomore in high school, so we're updating it to be someone else.
Makes perfect sense. Many of our savings, investment, life insurance accounts already have transfer on death beneficiaries. So the house and personal belongings are about the only thing in the revocable trust.
Oftentimes that's correct, but I don't like life. I like life insurance to go to a trust.
Me too.
And here's why. There are tax ramifications sometimes, but here's a scenario I was involved in 3 years ago. Husband was a passenger in the car. Wife ran the red light. It was a tragedy. It was wife's fault. She got sued. Husband died. Someone else was severely injured. The life insurance from husband's passing paid to the wife, not to a trust. The creditor, the other person she hit, sued the wife and took all the life insurance. Had the life insurance gone payable to a trust for the wife, the creditor would not have gotten it.
Yeah, that's the main reason as well. And you can make the case in the same way for the investment accounts on
Absolutely.
transfer on debt, depending on the situation. It goes back to what Lyle was saying a little bit earlier. If someone goes into a nursing home or what the situation is, for most people that might work just fine, but there's no absolutes in any of this, I think is the point, right?
And that's the whole point of, like, you don't set it and forget it.
Yeah.
You know, Hunter, you're married. I have no problem today with your IRA, for example, going to your spouse. But Hunter, if you call me tomorrow and say that, you know, she suffered an injury, or early Alzheimer's has set up, or, you know, I had someone relatively young have an aneurysm and in their early 40s going into a nursing home, then I have a real issue with the IRA going there. So it's just, and that's why your point was so well taken, that your financial advisor and your financial plan better include your estate plan, and they better walk sidestep together.
Yeah, no question. No question. Does the power of attorney document also include medical? I've heard you need both. You need both.
You do need both. You absolutely. Some people try to combine them, and I have seen that be disastrous. That people will go in and say, well, this one does it all. It's hard to have, you know, one document that does everything. I do not advise it. And also, you know, my mother has made me her power of attorney, but she has made my brother the healthcare power of attorney. I think she's worried that I want my inheritance early and I might pull the plug sooner, but whatever it is. But the point there is, you typically want a separate document for ease of administration, and you may be naming different people.
Okay, that's great. Just a few more here, although people keep typing some in, we'll keep going with them because these are good. How early can I start a Medicaid trust?
There is no limit. If you're above the age of 18.
Okay, all right. I thought that, and I think we touched on this, but Lori, I don't want to leave you. I thought the two things Medicaid could not touch are someone's home and car.
The car is typically correct. The home has never been correct. What the rule is that to certain limits, you can keep the house. But here's an example, mom and dad. Dad goes in the nursing home, mom does not. You got your survivorship deed, mom's in the nursing home, dad is still okay. Dad passes away. Now mom owns the home in the nursing home. In the beginning, you can say mom has the intent to return home for 6 months. After that, they're going to say sell it. If you don't, and please don't think you can sell it for $1. You cannot. Don't think you can say it's worth $300,000. I'm going to sell it for $100. You cannot. And a lot of people say, well, Medicaid never came in. Well, they don't at first. They put what's called a super lien on the property. And when mom passes, they send a letter that says, I am so sorry for Miss Jane Doe passing, period. Please note that Medicaid estate recovery is allowed to come after her assets, and we paid $184,000 to your mom. Sell the house, remit it, we get that much of the estate.
In short order.
Yeah. And so that's why the proper power of attorney and the proper trust is important. if a parent goes into the nursing home, you really desperately need the ability with the right documents to take the home out of both their names and put it just in the home of the spouse. That's not in the nursing home. And then that spouse, so the spouse who is still at home needs to update their estate plan, because most husband and wife say, if I pass, it all goes to my spouse. Fine. Not fine if that spouse is in a nursing home.
Yeah.
My general rule is don't ever direct assets to go to somebody in a nursing home, not through beneficiary designation, not through payable on death, not through on life insurance, and not survivorship on a house.
Yeah. Kathy, thank you for touching on the special needs trust. No problem, Kathy. No problem at all. Lori again asked, can you speak, and I think I know what she's talking about here, but can you speak to a ladybird deed on a home?
Okay. A ladybird deed is basically where you have deeded the property over, typically to a trust, but retained the right to live there, retained the right to sell the house and those things. That's a ladybird deed. You can do those. That starts the Medicaid 5-year window of you do the ladybird deed today, retaining the right to live there. If you make it 5 years, they can't touch it. But ladies and gentlemen, one thing to always remember, when you deed property, real estate, in most states, you want to deed it to a trust for the kids.
Yes, you do.
Because if not, and you deed the property to your child, a lot of states have a law called dowry and courtesy, which says any property the husband owns, the wife owns it as well, whether or not they're on the deed. To give you just an example to hit home, today, Hunter doesn't tell his wife, and he comes over to my house and he buys the lot next door. He pays cash for it, and I put the deed just in Hunter's name. So the deed now reads 100% owned by Hunter Nighbert. Guess what? His wife also has legal rights in that real estate. She didn't pay for it. She doesn't know about it. Her name's not on the deed, but his wife has rights in it. And another reason you typically deed property like that to a trust and not a kid, your kid may die before you.
Yeah.
Your kid may file bankruptcy. Your child may not like you at some point in the future. Your child may develop a disease or ailment and go on Medicaid. If you put that asset, be it your home or any other asset, just in your child's name, they may lose it.
Yeah. You also lose the tax advantage of inheriting it on death too. And what I mean by that, people, is when that house if you go on and deed that house, your tax basis goes early. And if they live another 20 years, the value of that house goes up. It is not owner occupied property. So the IRS treats it differently. The tax that you pay on it will be your basis plus whatever you sold it for. And as long as you've held it for over 12 months, you have a long-term capital gain, but you still have to pay 15% versus you getting it on the day someone died at the value it was on the day of their death. So,
and I always,
go ahead.
I just want to make the point that is where your financial advisor and estate planning attorney really have to walk side by side. I do not care how much you make. I care how much you keep.
Yeah, right.
You can sell a house for $1 million, but if you only walk away with $500,000 because of tax or something, you'd been better off selling the house for $600 and walking away with $599. I can't tell you how many times I've seen what I would consider people who don't have the skill set in this area, and some financial advisors as well, that they do things that cost a ton of tax.
Oh yeah.
And
I've seen attorneys do it.
Yeah, absolutely. I had an attorney here recently tell a person who was given 6 months to live. He told that person, let's make this easy. Go ahead and deed the farm to your kid.
Yeah.
Did not worry about the spousal rights. Oh, they'll never get divorced. Fine. What will your kid do? I'm sure he'll sell it. They've had the farm since 1919. They are going to have over 800,000 in gains. So the child, by doing that, was going to pay 200,000 in tax.
Wow.
Versus, luckily they hadn't done it, and he talked to me. We're going to pay zero tax.
Zero tax. Yeah, that's right. That's how you lose the farm.
That's how you lose the farm.
Literally. Okay. John, real quick, says most financial partners often offer a vault in your client portal where you can keep electronic copies of documents. You're absolutely right, John. That's available through some of ours as well. Eric, what are the risks of using Rocket Lawyer, LegalZoom, Trust and Will is one that I'm familiar with, online services to create these versus working with an attorney? Should you simply not have the right of survivorship on anything rather than just use a living trust and specify who receives title to anything? Intent of this question is to avoid confusion on what happens with any given asset at the time of death. That's a lot.
Well, so here's the reality. Rocket Lawyer and those things, it has been my experience, you don't know what you don't know.
Yeah.
For example, most people don't know that if they just leave the real estate to their child's spouse, that daughter-in-law or son-in-law has rights. Rocket Lawyer won't point that out.
Yeah.
That, for example, they ask the questions and say, all right, where do you want this to go? I want it to go to my child. What if your child passes away? Is it going on to the grandkids? Is it not? I am not a fan of those legal form documents because they are so general and so generic. They oftentimes don't work. I have seen the courts throw those out many, many times, and it concerns me because when I sit down with you, if you say, here, I'm very simple, Lyle, I want my assets going to my spouse. If my spouse isn't there, give them to my kids. We've still got 20 minutes of discussion about what if a kid passes? Do your kids have any issues? Are your kids above the age of 18? Do any of your kids have special needs? Are you leaving real estate? Is this a first marriage? Is it a second marriage? Do you have any issues with a kid being a spendthrift? I always tell everybody, you can get online and YouTube and watch how to remove a kidney. I mean, it is literally on YouTube. But I'm going to leave that to the doctors because they know what I don't know.
Yeah. Sure.
And again, and on the survivorship issue, survivorship can be okay. It can be terrible. And it just depends on the factual situation.
Last two, real quick. Thank you all for staying. I knew this is always one of the ones that gets a whole lot of engagement. And while we've got the expert, we'll just keep rolling. But two more. If you're still paying on your home, do you still put it in a living trust or only once it's paid off?
You can.
Yeah.
You just talk with the mortgage company and they, a revocable trust is so commonplace because of how great it was and what all it does that the banks universally, I mean, it's like going to Baskin Robbins and asking for vanilla ice cream.
And I'm assuming it's in most states as well. Kentucky, I know when I was in banking, what most people understand is you can change the titled name. It's always subject to the mortgage.
Correct.
The mortgage supersedes everything. It doesn't matter if it was in this one and there, it's still there. It doesn't go away. Now you can only sell it and transfer ownership once the lien, they won't release the lien unless it's paid off. In this case, you're not trying to pay it off. The mortgage is still in place, if that makes sense.
That's correct.
And then in what states is Lyle licensed to practice? This is, do you work with clients in other states? And if so, which ones? I mean, you work in several states, I know, Lyle, but if you have a network of people.
Right. I have a network of attorneys that I work with all over. We typically build trusts that are in different states. And it just depends. I always tell everybody, pull out your credit card. Well, I'm here in Kentucky. My credit card is not governed by Kentucky law.
Yeah.
And so you can set trusts up to be governed by different states, and I can help with that. And if
Sure.
not, we've got a network of people to do.
Yeah, and you're like you're part of the Elder Care Association,
Correct.
Elder Lawyer Association, which is a smaller, tight-knit group, and you want people that are going to be involved in those type of things because that's what they're doing full time. You don't have a whole lot of GPs. I know in some of those it's impossible for them to get into, quite frankly. Yeah, there has to be required. So that was it. You're welcome, Eric. I'm glad you enjoyed it. Any other questions really quickly? We'll take one more. Wealth of information, Patty says. You're very welcome. We appreciate you listening. For any of those that are catching this on the recording, you have any questions, shoot some. How do we reach Lyle? That's a great question. I'll tell you one thing. I'm going to send out a slide deck with this. I will put Lyle's contact information on that slide deck and a slide before mine. That'll go out sometime Monday afternoon, I would guess. So everybody's gone from the office already today. So we'll get that out early next week. And I will put, if you're in Kentucky or near the border states, we will pass along Lyle's information to you. So if there's no other questions, we're going to wrap it up. Thanks for attending. And I appreciate you guys being here.
You guys take care.
See you.